Hi, and welcome to Organizing Life's Daily Demands. I'm Peter Gordon. I'm the president of New York Financial Organizers. We're daily money managers. We help people pay their bills, process insurance claims, and deal with all the non investment side of finance. And the purpose of this podcast is to introduce other professionals who help people organize life's daily demands in other areas of expertise. And this morning, I'm thrilled to have Esther Zelmanovitz.
Zelmanovitz.
Sorry about that. That's, I'm sure, the first time that's ever happened. And she's a wonderful attorney and we work together. And I'm really excited to have her here. Welcome, Esther.
Thank you, Peter. Thanks so much for having me. I'm excited to be here and to share some information. Thanks.
Sure. That's right. Esther is got an ESQ at the end of her name, but she's not just any attorney. She's an elder law attorney and does trust and estate work as well. So I thought we'd start by you telling us a little bit about yourself and how you got into what you're doing.
Sure, Peter. So I'm an attorney practicing for a little more than 20 years. I started off really doing more of general legal work, and I felt that while it was interesting, it wasn't very fulfilling. And I really enjoy working with people, finding solutions, helping them through a difficult time. And years ago when I was practicing, leaving young children at home every day, I just felt like I want to do something more and more meaningful. And over the years, I basically started leaning towards elder law specifically. So what that is really is, for the most part, I am helping seniors with pretty much any of their estate planning and long-term care issues, as well as individuals that have special needs and need to seek government benefits. So that's pretty much what my practice is now. We're very focused on just these areas, and I love what I do, and I love helping people.
I love what you said. You wanted to do something more fulfilling. And that's generally the common denominator of the guests who come on here are people
Yeah.
who want to make a difference in the work they do and not just make money. And, we all need to make money, but there's more to it than that. And we know each other from a group that is made up of other geriatric care service professionals. And as I said, that's the common denominator.
Absolutely.
So, I mean, I know your work well and how important it is. And we actually have a whole list of questions, and there's a lot there to come, to bring forward. So let me ask you, if there was one or two documents that somebody should have, a senior should have, what do you think the most important ones are?
That's an easy one, Peter. The one most important.
That's why I asked it.
Yeah, okay, you're shooting me a softball. The most important document for anyone to have, you're going to be surprised, but well, you're not, Peter, but the general public may be surprised, but it's a power of attorney. A power of attorney is the most important document someone could have. Consider it an insurance policy. Basically, while you're an adult, able to do everything on your own legally and financially, then do it, no problem. The issue is, if God forbid someone becomes incapacitated and they no longer could, administer and deal with their daily finances, their daily legal issues, anything like that, no one has a default right to do that for them. And a power of attorney enables someone to choose someone that they trust, to name them as their power of attorney, and to give them the ability to figuratively step into their shoes and manage things on their behalf. And nothing is more important when someone's incapacitated. So yes, a will might be important, but that's regarding after lifetime. Of course, it could be very important for guardianship purposes if there's minor children and so on, but a power of attorney is absolutely the most important document you could have, because if you don't have it and you need it, the result could be more catastrophic, in my opinion, than any other document missing.
And so let's talk a little bit about what that result is. So what if God
Okay.
forbid
No, great. I could, I know we don't have that much time today, but I could give you lots of examples.
I know you can.
So just as an example, if someone, unexpectedly has a stroke or gets into a accident and they're left incapacitated where they don't have the mental ability or even physically can't get to the bank or can't do things on their own. No
Can't
one
sign their name.
can't sign their name, can't deal with any of that, anything that we take for granted that we do every day. No one could do it for them. A wife can't show up at the bank and say, I'm sorry, I need to get to my husband's, unless they're jointly held, the accounts. They can't just show up and say, I'd like to, access my husband's account to pay his bills. I need to, deal with the insurance company. I need to, and now those are just regular everyday things, but let's talk about even more of a crisis situation where somebody becomes so incapacitated that they might need institutional care or to have a home health aide in the house. Obviously, that could be a fortune. So, besides the catastrophic effect of not being able to access a person's bank accounts, there may be planning that could be done to be able to have the government pay for the institutional care or the home health aide at home without someone having a power of attorney that also specifically allows the agent in that form, in that document, to be able to do certain planning on their behalf so that they could access government benefits, that person could be stuck. They won't get the care they need unless someone else is willing to, pay for a tremendous cost of care. So we want to make sure that there's going to be someone that has been legally authorized to manage and handle and deal with any needs that an incapacitated person might need. And no one ever expects it to happen to them.
No.
No one thinks it's going to happen to them. And hopefully it won't ever happen to them. But if
it probably won't.
I'm sorry?
It probably won't, but that
Yeah,
doesn't mean
probably won't. But no one ever said, oh shucks, it didn't happen to me. So that doing that power of attorney was what a big waste, right? Like it should be a waste. It should be something that you just
right.
have.
Hopefully it will be. Yeah.
But just as an example, we have a client that absolutely needs care, and the family cannot afford the care. But guess what? She has money. The way it works with care, as you know, Peter, is that the government will pay for someone's care if their assets are below a certain amount with the Medicaid program. So there's planning that we could do to get someone's assets below that amount, whether it's shifting assets to a trust and so on and so forth. And but if we don't have someone that has power of attorney that allows them to create a trust on behalf of the incapacitated person, or to access never mind accessing their bank accounts to pay for the care, that's already one step, but now we want the next step of being able to protect their assets so that they could get care. So now we have a client that absolutely cannot provide for their loved one because they can't afford $15,000 a month to pay for the care. And we can't get Medicaid to pay for it either because nobody could access, this person's money to shift it over and their property to shift it over, and so that we could get the care we need. So the result of that is seeking a guardianship in court. And yes, eventually we could get there, but it could take many, many months, and it's really more expensive, very expensive, than just having done a power of attorney. And quite honestly, it could become a real mess if there's, multiple family members that all have different feelings and thoughts, and ultimately the court decides who the best fit is. So they may not choose a family member. They could choose, court-appointed guardian that will end up getting paid from that person's assets. So it could really be a real tragedy on top of a tragedy of an unexpected incapacity, illness or accident. So that to me is, as you can see, I'm quite passionate about that document.
No.
The most important document. When it's there, it's just amazing. And when it's not there, it's just catastrophic.
It's a large part of my business life, and and we deal with people. We become power of attorney for people, but then we deal with people who don't have power of attorney, and it can get really difficult. This runs into my next question: is when should you start preparing an estate plan?
Okay, so again, you won't be surprised, but maybe the general public, they're always surprised by this. at your 18th birthday. Guess
You're
what?
excellent. Great.
Why? Because no one knows when something might
Why? I'm
happen to
sorry.
you. What?
Why on your I didn't.
Yeah.
You said ask what?
I'm
Why on
figuring
your
the
18th
question. Yeah.
birthday?
Yeah. So, people think, well, I don't have a lot of money yet, or whatever their reason might be, they don't feel like they need to think about this. But honestly, if someone is 18 and a half years old and, God forbid there's an accident or something happens, their mom and dad can no longer, deal with any sort of legal matters for them. If they do happen to have some money in the bank, then they wouldn't be able to work with that and protect that for, being able to deal with the long-term care needs. If they end up in an emergency room, mom and dad don't necessarily have the right to get information and get medical updates. So we kind of take it for granted when our kids are under 18 that of course we have the legal right and authority to act on their behalf and to talk on their behalf and to make decisions and so on and so forth. And hopefully, at 18 years old, everyone's children are super responsible and, not going to ever need any assistance. But besides for even just regular assistance, if God forbid there's an accident, that's where it is so important to have these documents in place. So I would say
And
18. Of course, as you get older and as your situation changes, you accumulate assets or, you get married or, different things could occur, you would build on that. But I say, when should you start? 18 years old, get that healthcare proxy, power of attorney, going.
well, let's go into that. So, what's involved? What are the documents that can make up an estate plan?
Sure. So, obviously the power. So there's basically documents that you want to have, which we call advance directives for during lifetime in the event you become incapacitated. You want to have certain documents in place, and that would be the power of attorney, healthcare proxy. I also do a HIPAA authorization because a healthcare proxy only goes into effect if someone were incapacitated. But there may be a situation where their mental capacity is perfectly fine, but we still need to access information and speak with doctors on their behalf. So we want to have, a global HIPAA authorization. So those are advanced directives. Some people prepare a living will, which basically discusses their end of life wishes. So those are advanced directives. Then there are documents that, I'll talk about a trust in a minute. But then there's obviously the document for after lifetime, which would be a will. So you want to have that prepared as well. That's part of a basic plan. Having a will, basically it says who would be your executor, where your stuff would go. If you have minor children, who would be the guardian of those children? And obviously if there's any specific distributions or ways that you want things distributed, you can include that in a will. So that's the basic estate planning structure. In addition to that, some people add on, based on their particular situation, trust planning. So a trust could either be for the purpose of just making it easier to facilitate everything and administer someone's estate for after lifetime by avoiding the probate process, which I don't know if people may have heard of. It could be a very lengthy, costly process. So
We'll get back to that at the end.
yeah, so there could be reasons why people may want to do a trust simply for that purpose. But then there's also the idea of doing trusts for other purposes. It could be for, have protecting assets in light of the expected long-term care costs. It could be for estate tax purposes. It could be for special needs benefits purposes. So it could be because of children or beneficiaries that there are specific concerns. So the idea is that, a basic package would be the advanced directives and a will, and then sometimes, a trust in addition to that.
So you said the magic word there, probate, and most people don't know what probate is. I certainly didn't know about it until my father passed away, and there's a lot in there. But why don't you take a stab at a quick discussion of it?
Sure, no problem. So basically, if someone owns a bank account joint with someone else, then when the first person passes away, the second person could access the bank account. No problem, easy. if let's say someone has an investment account or some other savings account or anything with a beneficiary or a TOD, transfer on death, anybody that's listed that gets, or a life insurance policy with a beneficiary, then again, that beneficiary after lifetime, after that person passes away, will just get the assets. They'll get the policy, they'll get the money, and simple, right? When it comes to any assets that don't have a beneficiary or don't have a joint owner, then the next person can't just show up at the bank and say, oh, well, I'm so-and-so's wife or I'm so-and-so's child. It doesn't work that way.
Yeah.
Or with a property, a house, a co-op, right? If there's no beneficiary on those. So they can't just show up and say, well, I'm, the next person, I own it now. What happens is, and even if there's a will and the will says who the executor is and who the beneficiary, and when I say the word beneficiary, I'm taking for granted people know what that means, but the person who's entitled to the gift of that estate, the person who gets the money or the asset after the owner of that asset passes away. So what happens is, even if it's in a will, the court wants to make sure, and whoever is obviously buying or getting that asset after, we want to make sure that it's the legitimate person that should be getting that. So basically, there's a process. A will has to, if there's a will, and if there's no will, it's a little bit different, but very similar. You have to go to court. You have to tell the court who are the people, we call them distributees, who are the people that would inherit if there was no will. Okay, and that would be, there's an order to that in the law, a spouse, children, no spouse and no children, and parents, and so on and so forth. So we tell the court, these are the people that are supposed to inherit. They get notified. They have to really consent to the process. And then the court basically evaluates if there's a will, they look at the will. If there is no will, they make sure that all the distributees, the people who would inherit by law, are notified and part of the process. And then basically the court appoints someone to be in charge of the estate. It's an executor if there is a will. It's an administrator if there is no will. And then that executor or administrator now has the court appointed authority to collect all the assets of the estate, and then to pay bills and debts and so on. And then whatever's left, to give it, split it evenly, or however the distribution scheme is, through, basically the will or administration.
And how long does that process take?
So that's exactly it. It's not a day. It's not a week. It takes months. It takes months. And certainly we've seen over the last couple of years with COVID, it's just very unknown how long the court is going to take. It could take, right. So I can't really say that we've had so many that are years, not to really scare anyone, but honestly, there could be, and it does happen, where it's not always so straightforward, where the distributees, like I said, the people who inherit by law, are just the people that live in that household, right? It could be somebody that lives alone and maybe doesn't have a spouse or children, and their nearest kin is first cousins that they completely lost touch with. So the process of tracking down the distributees could take a long process. Then you could have them being notified, and it could be that maybe somebody has a will with giving everything to a charity or to their neighbor, and we still have to track down the distributees, and they either have to sign something, or there's another court process, and why would they sign it? Maybe they don't want. So the idea is that there's a lot of obstacles that could basically hold up the process. It could be that the court has wants to inquire further, needs more information, needs affidavits as to who the heirs are, and so on and so forth, and all of that could certainly delay the process, make it take more time. And then that's not even with an objecting party. If you have anyone that objects, that's where it could get really
you don't even go there.
Yeah.
So is there a way around that?
Exactly. So the way around that is by establishing a trust while a person is alive and putting their assets into a trust. You pretty much just bypass the entire court process. Nothing's public. Nothing needs to be told to distributees, those people who are your nearest kin. Nothing needs to be reviewed by a court or filed, and so on and so forth. And it's extremely smooth, because what you can do is, if your interest is avoiding that probate process, when you put things into trust, you could stay the complete owner of those assets. And when I say owner, really the trust is the owner, but you could be the trustee. You could be the sole lifetime beneficiary where you're the only one that has any ownership rights to that property. So it really doesn't affect or change anything for you during your lifetime, but you'll have that peace of mind knowing that after your lifetime, the person who you named as your successor trustee will just be able to step right in and be able to, distribute those assets without any court filings, without any court permission, without any notice, to other outside parties. And it's just an extremely smooth, easy process. And that also gives you the ability to further maneuver how those assets will be held after your lifetime. So it could
Gives
remain
you control. You have
a
control
lot of control
of your
So
legacy. Wonderful.
it's not exactly. So it's not necessarily for everyone that has a straightforward, and they don't mind. For example, you may have someone that's kids live in their house. And if they passed away, their kids would still stay in the house. So it wouldn't affect them as much to have to sit on an 8-month probate process or a 12-month probate process. But if you have someone that the family needs to sell the house after that person passes away, and they don't want to pay real estate taxes for another 8 months to 12 months. They don't want to have to not know when to time a contract of sale and when to tell a buyer that will be ready to sell, or, they don't want to pay the insurance and so on, all the carrying costs of a home for close to another 6 months to a year with trying to figure, time perfectly a sale, because you can't promise to sell something in a certain time if you don't know when the court's going to give you permission to do so. So in a case like that, a trust would be extremely advantageous.
So we packed in a lot of information.
Yeah.
And you did a phenomenal job of making it, as relatively simple as possible. I mean, it's complicated stuff, but it's critical to have, and to understand. It's always helpful to talk to someone else, and especially an expert like yourself. So how could people get in touch with you?
Sure. So basically, I have a website, nytrustlaw.com, newyorktrustlaw.com. Pretty easy to remember. You could certainly, access my website. There's a contact form there. You could also call my office. I have a regular number, but I also have an easy to remember number. It's 516-466-WILL, WILL. So, okay. So 516-466-WILL. And either of those two ways would be a very easy way to contact me. I would love to, speak with anyone that does not have an estate plan, that perhaps made an estate plan a while ago, perhaps made an estate plan and would like it to be reviewed. Like I said, I think that back to my initial comment about the power of attorney, it's not just about having a power of attorney. It's about having a power of attorney that has all the right provisions and is executed correctly. So check out, if you do have a power of attorney, check it out. Make sure it has Medicaid planning provisions. Make sure it has the ability for your agent to prepare a trust. If you downloaded it from the internet or you went on LegalZoom, there's a good chance that it doesn't have all the provisions needed in the event there's real incapacity. So just double check that. And, because like I said, that really is the key, most critical document that you could do to help yourself and help your loved ones help you.
So Esther's information will be in the podcast notes, as well as on the video, below the video in the notes there. And I highly recommend everybody reaching out to her. She's incredibly generous with her time. And she's a great source of information. And it's not simple stuff, but it's really, really important when the time comes, and she could be of great help.
Thank you. And likewise, Peter, you're also absolutely fantastic, very committed to your clients, and it's always a pleasure to work with you. And
Thanks very much.
Mm-hmm.
So that's a wrap. Again, thank you, Esther, and thank you everybody for listening. Don't hesitate to reach out to Esther with any questions. And I look forward to seeing you at the next podcast, or having you hear us at the next podcast. Bye-bye.
Sounds great. Thank you, Peter. Have a